So sticking with Asylum, because there was a lot of Asylum over the last month, is this decision out of the 11th Circuit called Jathursan v. U.S. Attorney General. That was on November 17th. And this is a Sri Lankan case. And for some reason, it seems the 11th Circuit has been publishing a lot of Sri Lankan asylum cases in a variety of contexts. And it's a pretty standard fact pattern for Sri Lanka asylum seekers. The guy was, he's an ethnic Tamil, and maybe he was part of the Tamil Tigers, but probably not. But he was certainly believed to have been a supporter of them by the majority ethnicity in Sri Lanka. And so that is often what these Tamil-based asylum claims are after the Civil War ended. And a lot of what the IJ and the BIA denied was affirmed, but the 11th Circuits, and this is the 11th Circuit, there aren't that many reversals of asylum in published decision in the 11th Circuit, I'll put it that way. But the 11th Circuit, as I read it, is saying and sent it back for consideration of whether Mr. Jathursan warranted asylum based on his membership in the particular social group of failed asylum seekers. And so that is really big to me, because that means the second the IJ denies, they've created a potentially viable particular social group. And that could be in any country. In this case, the 11th Circuit talked about news articles and other reports that indicated that failed asylum seekers are viewed by society as socially distinct and are harmed because they are believed to have said bad things about the government, for example. But that's kind of the case in a lot of countries, right? If people know what asylum is, you know that you're talking about the government. And it didn't even seem like Mr. Jathursan had that many news articles talking about what happens to failed asylum seekers. And so it seemed to me that the court was finding the particular social group viable and was just sending it back for an analysis on whether he'd be harmed on account of that. And so, I don't know, that seems big to me. That at a minimum, that means that practitioners maybe want to consider placing failed asylum seeker as one of their asserted grounds, just in case they do lose. And then there's automatically this group that an IJ and BIA should then consider. It's kind of circular. But it's there, and it's in the 11th Circuit.
Yeah, interesting. Well, this is like these. I mean, who knows how it'll go, but it's a kind of game-changing kind of stuff potential.
Right. I mean, I just put failed asylum seeker in the brief because of the decision. I don't want to be caught not doing it when the 11th Circuit says that it's viable depending on the country.
Very interesting. Well, people really need to listen to this podcast. I mean, if you're doing litigation or court stuff, this is really important. Asylum.